By 1916, the United States could not build a competitive fighting aeroplane, and the reason had almost nothing to do with engineering. Nearly every aircraft flown in America infringed a patent held by two bicycle mechanics from Dayton, Ohio, and those two men had spent the best part of a decade suing everybody who flew one. This is the story of what the Wright brothers actually owned and what enforcing it cost. We are going to go through how they solved a problem nobody else could, what their patent really claimed, why they stopped flying for 2.5 years at the height of their advantage, the rival who built his way around them, the 8 years of litigation that followed, and the emergency the government had to declare to end it. Start with the thing that is genuinely underrated, which is how good they were. Wilbur and Orville Wright ran a bicycle shop in Dayton. They had no degrees, no laboratory, and no patron. What they had was a mechanical trade, a good income from a seasonal business, and an approach to the problem that was completely different from everybody else's. What set them off was a death. In 1896, Otto Lilienthal, the German glider pioneer who had made well over 1,000 flights and was the most experienced airman alive, was killed when his machine stalled and fell. The news reached Dayton, and the brothers began reading everything that had been written on the subject. What they found in the literature was a field full of serious people getting nowhere, and they worked out why fairly quickly. Lilienthal had controlled his gliders by swinging his own body weight about underneath them. That works for a light machine and a fit man, and it does not scale at all, and everybody had accepted it as the way the problem was solved. They also had one advantage that mattered more than any amount of theory, which was a business that paid for itself. The bicycle trade was seasonal, hard work in spring and summer, quiet in autumn and winter. That gave them a reliable income and a workshop full of tools, and crucially, several months of every year in which they could do nothing but this. There was no investor to answer to, and no deadline anybody else set. Everybody else was trying to build a machine that would fly. The Wrights worked out early that the machine was the easy part, and the hard part was staying in the air once you were there. Lift and power were engineering problems with known answers. Control was unsolved, and nobody was working on it seriously because it only becomes the obvious problem once you have stopped crashing. So they went at control first, deliberately, before they had an engine at all. Their central insight, arrived at in 1899, was that an aeroplane has to bank into a turn like a bicycle rather than stay level like a boat, and that to do that you need to be able to raise one wing and lower the other on command. Their mechanism for it was wing warping. The wings of their early machines were built to be twisted, physically, by cables running to a control the pilot moved, so that one wingtip met the air at a greater angle than the other and generated more lift. Combine that with a movable rudder and an elevator at the front, and you have control in all three axes, which is what every aeroplane ever built has needed since. And here is the question this whole story comes down to, so put your answer in the comments before you hear mine. The Wrights invented powered flight, the patent was theirs, and the courts agreed with them every single time. So was suing everybody who flew the right call, or was it the mistake that cost them the industry they had created? See whether you still think the same thing by the end. Then they did the thing that really separates them. In 1900 and 1901, they flew gliders at Kitty Hawk in North Carolina, chosen for its steady wind and soft sand, and the gliders did not perform as the published figures said they should. Most experimenters would have blamed the machine. The Wrights concluded that the published figures were wrong. The 1901 season nearly ended the whole thing. The glider underperformed badly. The lift was a fraction of what the tables promised, and the two of them went home thoroughly beaten. On the train back to Dayton, Wilbur said, and it was remembered because of how uncharacteristic it was. That man would not fly for 1,000 years. He was over it inside a few weeks, and what he did with the discouragement is the most instructive thing about him. He did not conclude that flight was impossible. He concluded that the numbers everybody was using were wrong, which is a far more aggressive conclusion, because it meant discarding the accumulated published work of the entire field and starting the measurements again from nothing. Their correspondent through all of this was Octave Chanute, a distinguished civil engineer who had built railway bridges and who had made himself the clearinghouse of world aviation. He wrote to everybody, published what he was told, visited Kitty Hawk and gave the brothers encouragement, contacts, and criticism for years. He is the reason they were taken seriously at all before 1903. Hold on to Chanute because he comes back. His entire method was open publication, on the principle that a hard problem gets solved faster when everybody can see the working. That is the opposite of what the Wrights were about to do, and the two men eventually fell out over exactly that, publicly and painfully, in the last years of Chanute's life. So in the winter of 1901, they built a wind tunnel in the back of the bicycle shop. It was about 6 feet long, made of wood, with a fan driven off the shop's overhead belt. In it, they tested something in the order of 200 model wing surfaces, measuring lift and drag for different shapes, camber and aspect ratios, and they produced their own tables from scratch. That wind tunnel is the real invention, and it is the part that never gets a monument. Everybody else in aviation was working from data published by others, and that data was wrong. The Wrights were the only people on Earth flying to numbers they had generated and checked themselves, which is why their 1902 glider worked and everyone else's did not. By the autumn of 1902, they had a glider that could be flown, turned and landed reliably, hundreds of times, by a pilot who knew what he was doing. At that point, the engine was a shopping problem. No manufacturer would build them a light enough motor, so their mechanic Charlie Taylor made one in the shop in about 6 weeks. On the 17th of December, 1903, at Kill Devil Hills near Kitty Hawk, they made 4 powered flights. The first, with Orville aboard, lasted 12 seconds and covered 120 feet. The last, with Wilbur, lasted 59 seconds and covered 852 feet. 5 people watched, 1 photograph was taken, and almost no newspaper in America believed it. It is worth knowing why so few people saw it. Kitty Hawk was chosen because it had steady wind, open sand, and nobody in it. The witnesses that morning were men from the local life-saving station and a boy from the village, which is to say the only people within walking distance. The famous photograph exists because Orville had set up his own camera and asked one of them to squeeze the bulb. The press reaction was a mixture of silence and error. A few papers ran garbled accounts, some of them wildly wrong, and most ran nothing. For several years afterwards, it was entirely respectable in America to believe that the Dayton bicycle men were exaggerating, and that belief was not unreasonable, because the brothers were not showing anybody anything. Now the story turns from engineering to business, and it turns immediately. Because the next thing the Wrights did was go home to Dayton and spend 2 years flying in a cow pasture where nobody could see them. The field was Huffman Prairie, outside Dayton, and what they did there in 1904 and 1905 is arguably more impressive than Kitty Hawk. They turned a machine that could go in a straight line into one that could circle, bank, fly figures of 8, and stay up for over half an hour. By the autumn of 1905, they had a practical aeroplane, and nobody else was within 4 years of them. Huffman Prairie is worth a moment on its own, because it is where the aeroplane became a machine rather than an experiment. It was a small field with a fence and a tree at one end, And to get airborne in the light Ohio winds, they built a derrick with a falling weight to catapult the machine off a rail. Everything about it was practical and unglamorous. By October 1905, they were flying circuits of that field until the fuel ran out, well over half an hour at a time, turning at will and landing where they chose. Nobody else on Earth would do anything comparable for another 3 years. The lead they had at that moment was the largest technological advantage any two people have ever held in an industry that had not yet been born. Then they stopped. From late 1905 until the middle of 1908, the two men who could fly better than anybody alive did not fly at all. The reason was commercial, and it was entirely deliberate. They had something nobody else had. They had no way to protect it once it had been seen, and they had concluded that a public demonstration would simply teach the world how to copy them. So the policy was absolute. No flight, no photograph, and no detail until somebody signed a contract to buy. Understand what that policy assumes. It assumes that the invention is a secret worth keeping, that the buyers will come, and above all, that nobody else will get there in the meantime. 2.5 years of a technological lead were deliberately traded for a stronger negotiating position, and the trade only works if the lead holds. Meanwhile, they filed for a patent, and the patent is the second thing in this story that people misunderstand. It was granted in May 1906 as United States Patent Number 821393 for a flying machine, and it was not a patent on the aeroplane. Read what it actually claims, and it is narrower and far more dangerous than that. The core claim is on a method of lateral control, presenting the right and left portions of the wing to the air at different angles of incidence, in combination with a rudder used to counteract the resulting drag. That is a claim on the principle of controlled turning flight, not on any particular mechanism for achieving it. The patent attorney who drafted it, Harry Tallman, deserves a share of the story, because that drafting is the whole of what follows. A patent written on wing warping would have covered wing warping. A patent written on any means of presenting the wings at different angles covers wing warping, and ailerons, and anything anybody might invent later to do the same job. That distinction is worth sitting with, because it is the hinge of everything. If your patent covers a mechanism, competitors can invent around it and the market grows. If your patent covers a function, nobody can invent around it, because any solution to the problem infringes by definition. The Wrights and Tallman went for the function, and they got it. The clock on it mattered too, and it is a detail that gets left out of every telling. An American patent in that period ran for 17 years from the date of grant. Granted in May 1906, this one would expire in 1923, and every month spent in negotiation or in court was a month off a fixed term that could not be extended. They took out patents abroad as well, in France and in Germany, and those did not hold up nearly as well. The German courts in particular cut the claim back sharply, partly on the strength of descriptions the brothers themselves had published earlier, which counted as prior disclosure. So the strongest version of the monopoly existed only inside the United States, which turned out to matter enormously. Meanwhile, they were trying to sell. They approached the United States Army twice and were turned down twice, in terms that read badly now. The War Department replied that it required a machine to be brought to the stage of practical operation without expense to the United States, which is a polite way of saying come back when it works. The Wrights could not say that it already worked, because saying so would have meant showing it, so they went abroad. They negotiated with Britain, with France, and with Germany, and the negotiations dragged, because a syndicate being asked for a very large sum for a machine it has not seen fly is a syndicate that will keep asking to see it fly. They eventually took on commercial agents in Europe, a New York trading house with international connections, to run the negotiations for them. That is a reasonable move, and it did not solve the underlying problem, because no agent can sell a machine he is not allowed to demonstrate. 2 years went by in offers, counteroffers, options, and lapsed deadlines. Meanwhile, the money was going out rather than coming in. There were patent costs, travel across the Atlantic, machines built and shipped and crated and stored, and no revenue from any of it. The bicycle shop was still, effectively, funding the invention of aviation 3 years after it had been invented. In 1908, the deadlock finally broke, and it broke twice in the same summer. The Army issued a specification and the Wrights won the contract at $25,000 with a bonus for exceeding the required speed, and Wilbur went to France. What happened at Le Mans in August 1908 is one of the great moments in the history of technology. European aviation at that point consisted of machines that could stagger a few hundred yards in a straight line. Wilbur took off, banked, circled the field, flew figures of 8, and landed exactly where he intended, and the French audience understood instantly that everything they had been doing was a different and inferior activity. He flew over 100 times that autumn. He set records for duration and altitude that were not close to the previous ones. The doubters, and there had been many, publicly and generously retracted. For a few months, the Wright brothers were the most famous men in the world, and their commercial position looked unassailable. Orville, demonstrating for the Army at Fort Myer at the same time, had a propeller failure and crashed. He was badly injured, and his passenger, Lieutenant Thomas Selfridge, was killed, the first person to die in a powered aeroplane. The Army trials were completed the following year, and the contract was fulfilled. So by the end of 1909, the Wrights had money, fame, a company, and a patent that a court had not yet tested. And they had a problem, which is that during their 2.5 years of silence, somebody else had learned to fly. The Army's terms are worth quoting because they show what the invention was actually valued at by its first institutional buyer. The specification called for a machine carrying 2 men at 40 miles an hour for an hour, delivered for $25,000, with a bonus for every full mile per hour above the required speed, and a deduction for every one below. The Wrights beat the number and collected the bonus. $25,000 plus a bonus for the exclusive product of the most important invention of the century. It is a reminder that in 1908 nobody, including the buyer, had any idea what an aeroplane was going to be worth, and that the Wrights were negotiating hard over a price set by people who thought they were buying a scouting curiosity. Glenn Curtis was a motorcycle man from Hammondsport in New York State. He built engines, he raced, and he had held the title of the fastest man on earth on a motorcycle of his own construction. He was, by temperament and trade, the exact opposite of the Wrights, a builder who improved things by trying them, in public, quickly. Curtis came into aviation through the Aerial Experiment Association, a group set up by Alexander Graham Bell to develop a flying machine, with Curtis as its engine man. In 1908, the association's machine, the June Bug, flew a public kilometer and won a trophy offered by Scientific American, in front of judges and cameras, which is precisely what the Wrights had refused to do. And the June Bug turned using ailerons, which are separate hinged surfaces at the trailing edge of the wing, rather than a twisting of the wing itself. Mechanically, it is a completely different solution. Functionally, it does exactly the same job, which is to present one side of the wing to the air at a greater angle than the other. It is worth knowing what sort of man he was, because the contrast is the engine of the whole story. Curtis had held the outright land speed record on a motorcycle he had built himself, powered by an engine of his own design, at a speed that frightened the people watching. His instinct in the face of any problem was to build a version, run it, and build a better one next week. The trophy that the June bug won had been offered publicly with published conditions, and the flight was made in front of judges on a national holiday with photographers present. Every element of that is a deliberate contrast with Dayton. One side of American aviation was proving things in public and being copied. The other was proving nothing in public and being doubted. The Wrights wrote to Curtiss to say that he was infringing and offered a license. Curtiss declined. In August 1909, the Wright Company sued him, and the American patent war in aviation began. Their legal position was strong, and it kept being vindicated. In 1913, the court found for the Wrights, holding that the patent covered lateral control by presenting the wings at different angles, however, that was mechanically achieved, and that ailerons therefore infringed. In January 1914, the appeal court affirmed it. On the law, the Wrights were right, repeatedly and comprehensively. But look at what winning actually involved. The Wright Company did not sue one competitor. It pursued a general policy of enforcement. American manufacturers, foreign manufacturers selling into America, and individual exhibition flyers, who were told that flying an aeroplane in the United States required a license and that the fee was $100 per flight. That last one is the detail that tells you how the policy was received. Aviation in that period lived on exhibition flying. Crowds paid to watch men fly at county fairs, and the flyers, most of them young men with almost no capital, were the entire visible face of the industry. Charging them per flight made the Wright Company, in the eyes of the public and of every person in aviation, a toll collector. There is a bleaker chapter alongside it. The Wright Company ran an exhibition team of its own from 1910, flying for money at fairs, and meets in direct competition with the men it was suing. Exhibition flying in those years was appallingly dangerous. Several of the team's pilots were killed, and Orville shut it down within about 2 years, sickened by it. That episode is worth holding beside the licensing demands, because both come from the same decision. Having chosen to control the market rather than supply it, the company found itself simultaneously charging other flyers a fee per flight and sending its own young men up to do the same thing for cash. It is not a comfortable position, and the brothers plainly did not enjoy occupying it. Octave Chanute, who had done more than anyone to help them, said publicly that he thought the patent claim was too broad and that trying to monopolize lateral control was wrong. The two sides exchanged bitter letters. Chanute died in 1910 with the argument unresolved, and Wilbur went to the funeral. The people who had built the field were now on opposite sides of it. Curtiss, meanwhile, did what a builder does. He kept building, kept selling, kept appealing, and kept modifying his control system to try to fall outside the claim. One approach, developed with legal advice, was to rig the ailerons so that only one moved at a time, on the theory that the patent described the wings being presented at different angles simultaneously. It was a lawyer's aeroplane, and it was flown. He also went further, and this is the episode that poisoned everything for the next 30 years. Curtiss took Samuel Langley's aerodrome, the machine that had failed publicly and expensively in 1903, rebuilt it with modifications, and flew it briefly in 1914, in order to argue that Langley's design had been capable of flight before the Wrights, and that the Wright patent therefore rested on less than it claimed. The Smithsonian, which Langley had run, then exhibited the aerodrome with a label describing it as capable of carrying a man under its own power. Orville Wright regarded that as a deliberate falsification of the record, and his response was to send the original 1903 flyer to the Science Museum in London, where it stayed for 20 years, out of the country it had been invented in. Now, what did the litigation cost? Start with the brothers themselves because the first bill was personal. Wilbur Wright, who was the intellectual leader of the pair and the better businessman, spent the last 3 years of his life on legal work. He traveled constantly between courts, depositions, and lawyers' offices. He wrote that the lawsuits had taken time he had meant to spend on experiments, and the correspondence of those years is the correspondence of a man doing administration rather than engineering. In May 1912, Wilbur died of typhoid fever at 45. The family believed and said that the strain of the litigation had worn him down and left him unable to fight the illness off. Whatever the medical truth of that, the plain fact is that the most capable aeronautical mind in the world spent his final years in courtrooms and produced no significant new work after 1909. One thing before we go on. If you subscribe, it genuinely helps this channel keep going, and there is a new piece of American financial history every single day. If you want the next one, that is all it takes. Orville, who had never wanted to run a company, kept the suit going and then got out. In 1915, he sold the Wright Company to a group of investors for a figure generally given as around $1.5 million, which was a great deal of money and which he had earned. He spent the remaining 33 years of his life as an elder statesman of aviation, not as a builder of aeroplanes. So the founders' return on the greatest invention of their age was one company sale and a set of court victories. That is not nothing, and it is a fraction of what the same invention was worth to the people who came after them. Now the larger bill, which fell on everybody else. While the American industry was fighting over who owned lateral control, the European industry was building aeroplanes. The patent was enforced in the United States, and European manufacturers largely ignored it or worked around it in jurisdictions where the Wright claims were weaker. France in particular had an aviation industry that was competitive, well capitalized, and openly experimental, with dozens of firms trying different configurations against each other in public competition every season. The results were exactly what you would expect. Between 1909 and 1914, the center of aeronautical progress moved from Ohio to France and Germany. Engines got more powerful, airframes got stronger, control systems standardized on ailerons because they were better, and the practical performance of a frontline European machine pulled steadily away from anything being built in America. You can see it in what the two industries were producing. In France by 1913, there were dozens of firms, competing openly at flying meets with prize money attached, iterating designs season by season and selling to several governments. The whole structure was a public tournament in which every entrant could see what every other entrant had tried. In the United States over the same years, the industry consisted of a small number of firms, at least 2 of which were spending a serious fraction of their management attention on litigation against each other. New entrants had to weigh the cost of a machine against the near certainty of a letter from a lawyer. That is not a market failure caused by bad engineering. It is a market shaped by a legal position. By the time the First World War began in 1914, the country that had invented the aeroplane was not a serious producer of them. That is not a rhetorical flourish. When the United States entered the war in 1917, the American Air Service went to France and flew European aircraft, because there was no American combat design worth putting in the line. The best-known American production program of the war was building a British design, the DH-4 under license, fitted with an American engine. It arrived late, and the aircraft procurement effort as a whole became a national scandal that was formally investigated. The country that had first flown in 1903 spent the war buying its fighting airplanes from the people it had taught. The scale of the effort makes it worse rather than better. In 1917, Congress voted an enormous sum for military aviation. By a distance, the largest single appropriation it had ever made for one purpose, on the promise of darkening the skies over Europe with American aircraft. What came out the other end, in combat aircraft of American design at the front, was close to nothing. That failure had several causes, and it would be dishonest to lay all of it on one patent. Engine development, the shortage of trained designers, and a procurement system inventing itself in wartime all contributed. But the reason there was no mature American aircraft industry in 1917 for the money to be spent through is a question with a much shorter answer, and the answer is what had been happening in the courts since 1909. And this is where the government finally intervened, because it had to. The problem in 1917 was not that America could not build aircraft. It was that any manufacturer who tried faced an immediate patent claim from one side or the other, and no company would tool up for mass production with that hanging over it. A committee was formed to deal with it, and the recommendation was a cross-licensing pool. The Manufacturers Aircraft Association was set up in 1917, and essentially every aircraft patent in the United States was pooled into it. Any member could use any patent. A fixed royalty was paid on each aircraft built, and it was divided between the two principal patent holders, the Wright-Martin interest and the Curtiss interest. Look carefully at what that means, because it is the most important sentence in this video. The dispute was not resolved by a court. The courts had already resolved it, in the Wrights' favor twice. It was resolved by the federal government deciding that the correct outcome of a valid patent was not going to be permitted, because the country needed aeroplanes more than it needed the patent system to work as designed. That is a compulsory license in all but name, and it is one of the clearest examples in American history of a property right being overridden not because it was invalid, but because enforcing it had become intolerably expensive to everybody else. The Wrights won every case and then lost the war of them. At the moment, the stakes got large enough for the government to care. The royalty rate agreed in the pool is the final indignity, and it is worth stating plainly. Against the ambitions of the enforcement campaign, which had aimed at a license on every airplane that flew in America, the pooled royalty was a modest per aircraft, some divided between the parties. The Wright patent, the strongest patent in the industry, ended as a line item in an industry-wide agreement. It is worth comparing that with how the same problem was handled by people who thought about it commercially. A patent holder who wants an industry to grow inside his monopoly licenses on standard terms publishes the rate and makes it easier to pay than to fight. The rate is set low enough that designing around it is not worth anybody's engineering time, and the holder collects on every unit anyone sells, including the units invented by his competitors. That strategy converts a legal right into a stream of income from other people's ingenuity, and it grows with the market rather than capping it. It was available to the Wrights from 1906 onwards. They had the strongest patent, the earliest position, the most credibility, and after Le Mans, the most famous name in the industry, which is as good a hand as anybody has ever been dealt for exactly that play. What they did instead was treat every other aeroplane in America as trespass. The distinction is not a moral one, and it is not about generosity. It is a straightforward question about which arrangement produces more money over 17 years, and the enforcement strategy produced less, in a market that a licensing strategy would have made enormous. And then the two names converged. In 1929, the Wright Aeronautical Corporation and the Curtiss Aeroplane and Motor Company merged, and the combined business was called Curtiss-Wright. The company that resulted from 20 years of litigation between two founders carried both their names on the same letterhead and still exists. The pool outlived the emergency that created it by a very long way. It was set up as a wartime expedient, and it simply carried on afterwards, with the manufacturers cross-licensing each other's patents as a matter of routine for decades, until the arrangement was eventually unwound under antitrust pressure long after everyone who had started the quarrel was dead. That is the ordinary fate of an emergency measure that works. Nobody has an incentive to dismantle it, because the alternative is going back to a situation everybody remembers as intolerable. The American aircraft industry spent most of the 20th century operating under a patent settlement written in a panic in 1917. The original flyer, meanwhile, stayed in London until after the Second World War. Orville had made its return conditional on the Smithsonian retracting its claims about Langley's machine, and the institution did so, and the aeroplane came home. Orville died in 1948, a few months before it went on display in Washington. So back to the question. The Wrights invented it, the patent was theirs, the courts agreed every time. Was suing everybody the right call, or the mistake that cost them the industry they created? The case that they were right is the strongest version of the case for patents in general, and it deserves to be made properly. They took the risk. They spent 4 years and their own money on a problem the great institutions of the age had failed to solve, including a government-funded program under Langley that had spent public money and produced nothing. They built the wind tunnel, they generated the data, they flew. And what they were protecting was not an accident. Curtis did not independently arrive at controlled flight. He arrived at it in an environment that had been transformed by the Wrights' demonstration that controlled flight was possible, and roughly how it was done, which is exactly the free ride a patent exists to prevent. If a man who solves a problem of that magnitude cannot own the solution, the argument for spending years on hard problems gets a lot weaker. The case that they were wrong is not that they lacked the right. It is that they used it in a way that destroyed the value of the thing they were defending. Consider what a patent is worth. It is worth a share of the industry it enables, and a share of a large industry beats all of a small one. The Wrights had a 14-year monopoly on the single most valuable technology of the century, in the largest domestic market on Earth. The strategy that maximizes that position is to license widely at a rate every manufacturer can pay, take a small cut of a rapidly growing industry, and let the industry grow inside the patent. They did the opposite. They set out to restrict, to charge per flight, and to stop rivals rather than earn from them, and the effect was to push development to countries where the patent did not run. By 1917, the American aviation industry was so far behind that the patent's remaining value was academic, because the thing it was a share of had failed to develop. And the strategic error started earlier than the lawsuits, which is the part worth taking away. The 2.5 years of not flying were the same mistake in a different form. Both decisions treat the invention as a secret to be guarded rather than a position to be built on, and both trade time, which was the only thing they could never get back. For legal certainty, they turned out not to need. The honest verdict is that they were entirely within their rights and comprehensively wrong about their own interests, and that these are not intention. A patent is a license to exclude. Nothing in it obliges the holder to think about whether excluding is the profitable move, and the Wrights, who were superb engineers and ordinary businessmen, did not distinguish between the two. There is a wider lesson in it that has been repeated in every technology since. The first mover's advantage is real, and it is short. It decays at the speed the rest of the field can learn, and litigation does not slow that down, because a lawsuit constrains what a competitor may sell in one country and does nothing whatever to constrain what he may learn. Curtis understood that, and the Wrights did not. He lost in court repeatedly and kept building aeroplanes, and each machine was better than the last, and the eventual settlement found him in possession of a working factory and a product line. The Wrights won in court repeatedly and stopped developing, and the eventual settlement found them in possession of a judgment. The final accounting is short. Two men solved the hardest engineering problem of their era in a bicycle shop with their own money in about 4 years. Then they spent the next 8 defending it, and the government of their own country eventually had to set the result aside in order to buy aeroplanes for a war. The invention was worth everything. The exclusive right to it turned out to be worth a royalty, split 2 ways on somebody else's production line.